Good afternoon, everyone, and thank you so much for joining us for our Aging at Altitude series. Today, we have for our Lunchtime Conversations webinar, our Senior Law panel. So my name is Lindsay Haynes. I am the event manager with Prairie Mountain Media, and I will also be the moderator for today's session. So whether you are joining us today on your computer, mobile device, or even a tablet, we have the option to share with you our question and answer, as well as our chat box that's you can find at the bottom of your Zoom screen. So today, since we have two speakers presenting, if at any point during their presentations you have any questions, you can chat those or even insert them into the question and answer box, and then we will go into our question and answer session following both presentations. So today, starting us off, we have Diedre Braverman, Esquire with the Braverman Law Group. She will be presenting on trusts and then probate and asset protection for you and your beneficiaries. Following her presentation, we will transfer over to Susie Germany. She is the owner and lead attorney with the Germany law firm, and she'll be covering critical legal documents and just covering everything important and what you need to know. So that being said, I will go ahead and turn it over to Diedre, and she will get us started.
Hello. Hello, everyone. Thank you for joining. Does my sound good, Lindsay?
Yeah, you sound great.
Okay, great. Thanks for joining. I'm Diedre Braverman. I'm going to put a presentation up on the screen so you've got something more interesting than me to look at. There we go. Trust, probate, and asset protection for you and your beneficiaries. And we're going to go through it as 10 mistakes to avoid. First, I want to tell you just a little bit about me. I've been planning estates for over 20 years. I know that because my kids are 21, and I started by planning my estate to take care of them when they were born. Then I expanded into planning estates for other moms and dads I knew, and pretty soon I had an estate planning practice. I'm a graduate of Stanford Law School and the University of California at the Irvine campus. If there are any classics majors out there, yay! That's Latin and Greek. It's not too common, but we stick together. I have been quoted in national media like the New York Times and the Wall Street Journal on asset protection topics and estate planning topics, and I was interviewed on Fox Business News about special needs trusts. I am an educator of other attorneys. I teach multi-day intensives on estate planning to attorneys who are new to the field. I teach 1 and 2 hour workshops to attorneys who are experienced in the field and want to know about something specific. And finally, and perhaps most importantly, I am the mom to twin 21-year-olds who took very different paths so far in life. One followed me to Stanford and is getting his undergraduate degree there. And the other one is struggling with mental illness issues that are preventing him from even going to school. So I've dealt with that in my estate plan. I started dealing with special needs plans because my brother is autistic. So when I started estate planning and wanted to help my parents, it was natural to figure out how you can plan for someone with autism or mental illness or a physical disability. I want to let everybody know that we have a giveaway at the end. It's our Family Asset Protection Survival Guide. It's 71 pages long, and it covers a lot of topics that we won't get to today, like Medicaid planning, LLCs, advanced estate tax planning, planning for businesses, and investment real estate strategies. So stay with me to the end, and I'll tell you how to get it. The first mistake to avoid is dying with no will or trust. That's called intestate, because you are a testator if you create a trust. The problem with dying with no will or trust is you haven't given any instructions about where your assets will go, and you haven't given any instructions about who will manage them after you're gone. So they could sit dormant until someone figures out that they need to go to an attorney and open a probate, or the family could panic. It's In any case, it's not pretty for the survivors when there's no plan at all, because things can go in all kinds of different directions. Critical mistake number two, which couples often make, is to have just an I love you will. That's a will that says I leave everything to my spouse. Now, that goes through probate, which is a process you may want to avoid, and then it goes to your spouse. But what happens when your spouse dies? You've left your spouse holding the bag to do all the estate planning, perhaps at a very advanced age and with limited capacity to do it. Mistake number three is owning property jointly in joint tenancy or as tenants in common. When you own it as joint tenancy, you have the same problem that you did when you had an I love you will. You give the property to the other owner when you die, or when they die, you get the property, but there's no planning beyond that. It's just a one stage plan, and it doesn't go very far. With tenants in common, there's no plan. The property doesn't go to the other owner when one dies. So tenants in common is to be avoided except in investment scenarios. Now we've got a reason to use a trust. Elaine, your husband's next wife. In the month since your death, she's brought your husband home cooked meals 6 times. Each time she visits, she wears a skimpier outfit. She can't wait to redecorate your home. And worst of all, she thinks there's no good reason money earmarked for your children shouldn't be spent on more important things like jewelry and European spa vacations. Do you want her to spend your children's inheritance? It's not an idle question. Using trust, you can plan to avoid a situation like this. In particular, you can include remarriage provisions in your trust that say if my spouse remarries, they have to have a prenuptial agreement that meets certain requirements to protect the kids, or they don't get any more money out of the trust. Critical mistake number 4 is giving property outright to your kids. Outright meaning not in a trust. So you may have no estate plan, intestate. In that case, it would go to your kids outright. You may have an I love you will. In that case, it would go through probate and to your kids outright. Or you may have a will that says after my spouse, it goes to my kids, but there's no trust in there. So it goes to the kids outright. What are the dangers of leaving money to your kids outright? Well, first of all, you have kids like Marvin here. He's a serial entrepreneur. He's started 16 businesses and all have failed. He's asked you to financially back them. He's gone bankrupt twice. He owes over $100,000 in legal fees and back taxes. Is it really a gift to leave your life's work to him? Or would it be more of a gift to leave it to him in a trust that protects it from his future bankruptcies and bad management? Another reason to create a trust for your children is your children's spouses. So here we have your son-in-law, Fred. He hasn't been employed since 2017. He belongs to a religion you consider a cult. He sells t-shirts for a band you've never heard of and don't want to hear. And he appears very fond of chemical substances. He thinks it's great he has you as his rich in-laws. If you leave your assets outright to your daughter and they get divorced, Fred may be able to take half of them away in the divorce. If you leave them to your daughter in a trust, that won't be possible for Fred. Your daughter will keep the benefit of all of those assets. And if your daughter is a good money manager, you can even put her in charge of the trust. Mistake number 5, not having a trust. So the first kind of trust you want to have, and this is if you own real estate or have assets above $77,000 that don't have beneficiaries on them. If that's the case, you want a revocable living trust to start with. A revocable living trust avoids probate. And I know Susie's going to talk a little bit about probate. I'll just say briefly that probate is a court supervised process. It transfers assets from someone who's died to the people living, either through the will or through the state of Colorado's plan, which is what you get if you don't make a will. And there are some downsides to it. First of all, it's more expensive than trust administration. Second of all, it can't be done in the attorney's office. You have to go to court when you're doing probate, and court makes a lot of people uncomfortable. So you're kind of forcing court on the person you're asking to take care of your estate, the person you need to be kindest to. It's also public. So your kids' names and addresses are part of the public record. Your assets are part of the public record. They're definitely going to get some advertisements from car dealerships and realtors, and they may get worse. They may have people showing up pretending to be friends who are not friends. Now, once you have a living trust, you need to make sure you put your assets into the trust, because the way it avoids probate is by not having anything owned in your individual name. So when you die, there's nothing that needs to be probated. So you've got to get all your assets owned in the name of the trust. There are some exceptions. Retirement plans, you're going to make the trust a beneficiary instead of an owner. But the trust should be listed somewhere on just about every asset you have in order to avoid probate. Now we've got another reason to make a trust, the Farkles. This is your daughter's in-laws. They've accepted 126 invitations to dinner from you without reciprocating once. They love to spend time at the house you bought for your daughter, especially the pool. And you can't have a conversation with them without RVs coming up, which Big Al happens to sell. Are you sure you want them to enjoy your daughter's inheritance? With a trust, you can specify how money is used and how it isn't used. And you can certainly dictate where it goes when your child dies, so that it stays in your bloodline and goes to your grandchildren and not to a spouse who could die and leave everything to their parents. Mistake number 7 is not having your documents reviewed and updated. A lot of people create a revocable living trust plan and they think it looks great. It's in a 3-inch binder, it's organized, it's got all these documents, and they think we're set. And then they don't check it again, ever. When they die, there are all kinds of problems. People they have named to take care of their estate have died before them or don't want to do it. The provisions for their kids are out of date. They say they get a trust until they're 25 and the kids are in their 40s. The healthcare agents they chose to make medical decisions for them have moved to Hong Kong and Britain. all kinds of things can happen, uh, even without legal changes. There are legal changes, though. One of them I'm going to talk with you a little bit about today is estate tax law, but there are also changes to healthcare law. HIPAA was a big one that changed how all of us did estate planning. There can be state law changes that affect wills and trusts. So you should have your documents reviewed and updated. I would say you should look at them every year to make sure the people you named are still the people you want. And then every 3 to 5 years, you should come see your attorney and look it over with them so that any legal changes can be incorporated. Mistake number 8, I promised we would talk about estate tax. Choosing the wrong year to die. If you had died in 2010, there would have been no estate tax. That year had no estate tax. But if you die between now and 2025, you can leave $11.7 million without any estate tax. If you die after 2025 or during 2025 or after, the exemption goes down to 5 million. Now, because Biden has won the presidency, we may well see his proposal for a $3.5 million exemption be adopted by Congress this fall. That's the latest word from the New York Times. And the other thing the New York Times said was that the estate tax rate may go from 40 to 60%. So 60% of everything you have above $3.5 million would go to the federal government. In Colorado, we have no state estate tax, so we're lucky there. We don't have to pay 2 estate taxes. Don't move to New York because they have a big estate tax. But even though you didn't die in 2010, we can still help you plan for these various scenarios so that your plan is flexible enough to deal with whatever the exemption is. Now, Susie's going to talk more about all these other documents you need, but thinking a living trust alone is a mistake. You need, and you can see on here, a will. Your will leaves everything to your trust in case you left anything out of it. We offer a family meeting where we sit down with the people you named in your trust to do things like be your healthcare agent or be your trustee, and we explain to them their role. We share the key parts of your document with them so they understand, and they get introduced to us so they know they can always call us for a PDF copy if they can't find your binder. Other documents, we include a 24/7 healthcare emergency wallet card. That holds your healthcare documents on file. And if you're ever taken to the hospital unconscious, they pull that wallet card out from behind your driver's license, call the 800 number, and get all of those healthcare documents faxed to them. So I'm not going to go over everything on this page, but I think Susie will cover a lot of these. The bottom line is living trust is not what you're getting. An estate plan is what you want. Mistake number 10, the worst mistake, not understanding that the biggest enemy is not probate, it's not taxes, it's procrastination. If you're here and you've never planned your estate before, you know how true this is. Or if you're here and you haven't looked at your estate plan in 10 years, you know how true this is. So I liked the 3 Ds I came across in a book somewhere on how to overcome procrastination. One thing you can do is you can delegate. And delegating to us makes a lot of sense. We will guide you through the process. We'll tell you when we need to schedule appointments. We'll tell you what information we need from you. We'll ask you questions to develop your wishes so that things you may never have thought about before can come up and inform your estate plan. So by contacting us, we will take over the planning and you can be in the passenger seat. The second way to overcome procrastination is to dump it. So if you're having trouble planning your estate, you may need to dump less worthy tasks. They might feel more urgent, but they might be less important. So you need to postpone those. And finally, the way to overcome procrastination is to just do it. Make an appointment for a free consultation right now. In fact, get out a pen and paper because I'm about to tell you about the free gift and you're going to need to write something down. The free gift, the Family Asset Protection Survival Guide that I wrote. I wrote it, 15 years ago, but I revised it just 2 years ago, so it's up to date. It's 71 pages long, and it addresses topics that we weren't able to cover today, like conservatorship, Medicaid planning, LLCs. It's a resource you can turn to for these various topics over and over again. So for your free copy, just contact Melanie. Her information is on the screen. Write it down. It's MELANIE at Braverman with a V -law.com, or you can call her at 303-800-1588. Now let me see here. I think, yep, that's all I've got for you. So I'm really looking forward to your questions. Thank you for attending.
Wonderful. Thank you so much, Diedre. We will go ahead and switch over to Susie's presentation right now. And so don't forget, if you have any questions that cover the presentation that Diedre had, go ahead and submit those in our Q&A box or just send us a chat. So I'll go ahead and turn it over to you, Susie.
Thank you very much. I appreciate it. I am working on the PowerPoint switch here. All right, hopefully that will work there. Okay. All right. Thank you, everyone. I appreciate you attending this afternoon. And Diedre, thank you very much. It's funny because I wrote this presentation without even conferring with Diedre. And it's funny because a lot of the topics that she covered are it really streamlines and dovetails with what I'm going to talk about next. And it's funny because I think I recognize a lot of those family members that she was talking about. I'm pretty sure that we deal frequently with a lot of those issues. So what I'm going to start with is really just a little background about our firm. So our firm's been around for about 16 years, and I've been a practicing elder law and estate planning attorney and probate attorney in Colorado and Alaska for a number of years, and also do a lot of special needs planning. I also am a deputy public administrator, and what that means is that I am appointed by the court oftentimes to serve as a conservator for people, or to administer an estate as a personal representative, or to serve as a trustee, especially in the event of conflict or something really has gone wrong where there was no planning or there was really poor planning put in place. And so a lot of what I'm going to discuss today are the common issues that we see in our office and the critical documents that people really should have in place, in addition to the will and trust type of planning, to deal with disability or anticipated disability issues, or dealing with incapacity. And so I'm really going to start with just talking about how, at this point, what the most common questions are that we have. Hang on just a second here. I have to switch over here. Okay. For some reason, we're having some IT issues here. So hopefully everyone can see that. So essentially at this point, what we often see is that people will call us and ask questions about, what do I do in the event that my mom has Alzheimer's disease and I need to have a way to make decisions for her? And what it's really going to come down to is ultimately, at the end of the day, people have to have a way to make those decisions if mom's not able to make those decisions for herself. And so the most critical ways she can do that is really to make sure that she's got the proper documents in place and that she's got the, the proper ability to delegate those decisions in the event she can't make those decisions and she's already lost capacity. So really at the end of the day, people need to look at what is my plan for disability. Not only do I have a trust in place, but what other kinds of documents do I have? Do I have a HIPAA authorization that would allow someone to look at my medical information, to talk to my doctors, to go get my medical records? Access is half the problem. If you've got a family member, for example, who already has lost capacity at this point, and they cannot make those decisions, they don't have capacity any longer to sign a valid power of attorney, for example, which we're going to talk about in a minute, then you might need to look into guardianship and conservatorship issues, which we're going to dive into more in depth here shortly. So at this point, the biggest things that I always recommend to people is making sure you've got some really basic triage documents in place. And by that, I mean, especially with the COVID epidemic, it's really become apparent that people need to have a medical durable power of attorney in place. That is extremely crucial. A medical agent under a power of attorney has the ability to make medical decisions for someone else if they're not able to make them for themselves. I think we're having some issues. Hang on. Bear with me here a second. I don't know why we're having issues. We are. So we're trying to get through these. Okay, here we go. Looks like we got it figured out. So the medical durable power of attorney, in essence, has to do with being able to make those critical medical decisions if you're not able to make them for yourself. So in Colorado, there is also a proxy law. If someone doesn't have a medical power of attorney in place, there is the ability for someone to make a one-time life and death decision for someone else, such as, in a critical care situation, but it doesn't enable them to make ongoing long-term medical decisions. For financial management, another document that's important is a financial durable power of attorney or a general durable power of attorney. And those documents are extremely important in terms of assessing what roles you want people to be able to play. So for, as I mentioned before, for medical decision-making, you have a medical power of attorney. For finances, you're going to have a financial durable power of attorney. But the choice of those individuals is critical. And so that's something where you really want to think carefully before you choose people to fill those various roles, or to fill the role as a personal representative for your will, if you have a will. And that's what in Colorado, other states may refer to it as an executor. Colorado calls it a personal representative. And then a trustee for your trust. And those are very complex roles, and they can create a lot of different issues as to conflict of interest. For example, if you name your child as a trustee, and even though you may really trust that child, and that child may be a great money manager, will the fact that your child may be serving as a trustee create some friction amongst all your family, amongst their siblings? And so I think that's really critical. At the same time, you might want your best friend, for example, to be your medical agent under power of attorney. And because they know your end of life wishes, they're going to carry those wishes out. Whereas you might have some reservations about having someone else do it, such as a child who might not be willing to carry out end of life decisions. So it's important to think about who you're choosing in these various roles as your medical agent, your financial agent, personal representative, or your trustee, and what kind of qualifications do they have? And that may sound funny because people will say, well, I'm going to name my oldest son because he's my oldest son. But as Diedre mentioned in her presentation, if your oldest son has had a lot of financial issues, that may be a situation where you do not want to name that oldest son. You might want to consider a professional or consider someone else. but those documents are definitely necessary. The other issues that we frequently see, and when we might be serving as a fiduciary in cases, or we're advising a fiduciary, we're representing a personal representative, or we're representing an agent under power of attorney for mom, for example, we see a lot of issues that come up about elder fraud, elder exploitation, and undue influence. And so this is an example here of Mickey Rooney, who was someone who was unfortunately a victim of undue influence by his caregivers. And there are a lot of different examples out there of these kinds of cases. And in that situation, he had signed his will just weeks before his death. He left his entire estate to his stepson, who had been his caretaker, and his other children were barred from seeing him. And he ended up losing most of his fortune because of mismanagement by other family members. And unfortunately, these cases are very common, I hate to say. I also want to mention, what happens if people don't have these documents in place? What if a person doesn't have a medical durable power of attorney? Then guardianship may be necessary. And really simply put, guardianship is the process in the courts in Colorado where someone would petition to become the person to make health, safety, welfare, and medical decisions for someone if they're no longer able to make those decisions for themselves, and they've never executed a medical power of attorney, or unfortunately may have chosen the wrong person. Important things just to know is that it is a formal process through the court, through the probate courts, and your letters of guardianship are the official piece of paper that you get at the end of the day with your court order that evidences your authority. There's been a lot of stuff in the press in the last year or two about bad guardians and bad conservators, or issues surrounding guardianship and conservatorship. There was recently a Netflix special called I Care a Lot, which is kind of terrifying, about a guardian who goes rogue. And the good part about Colorado is we have a lot of checks and balances in our court system and a lot of oversight of guardians and conservators, both professionals and family members. But that's just something to realize, that if you don't have proper documents in place for planning for incapacity, you could find yourself, or you may have to seek guardianship or conservatorship for someone else. Conservatorships have been a big topic as well in the recent months. Britney Spears' conservatorship has come up quite a bit in the news because her father is currently her conservator who manages her financial affairs. So in some states, a guardian may handle both finances as well as care decisions, but in Colorado, those are separated. And so you have a guardian to make health, safety, welfare, medical decisions, and you have a conservator to make financial decisions. And so again, the conservatorships are brought in the probate courts in Colorado and are very carefully overseen by the probate courts. And there's a lot of reporting required both for guardians and conservators to the court. So there is oversight. So a big thing to know about conservatorships, they can be expensive and they can be really time consuming. And like guardianship, has to go through a court process, and that can create a lot of stress for the person that the conservatorship or the guardianship is being sought for. And it can also be a lot of stress on families. And that's where we see a lot of conflict and a lot of contested matters that come up. Some other example of people who've had conservators in the past, Amanda Bynes, and my assistant had to remind me who that was because he's much younger than I am, and the Beach Boys, Brian Wilson, Joni Mitchell for a time had a conservator after she suffered a brain aneurysm, and one of my favorite bands, the Eagles, their bass player, Randy Meisner, at one point had a conservator. So it can happen, and a person does not have to be deemed to be completely incapacitated to have a conservator. They may have health issues or other things like substance abuse or mental health going on, where they require some additional assistance with managing their finances. But again, that's kind of the choice of last resort. If someone has not done a financial power of attorney, then conservatorship would be the other resort, the other last resort. As Diedre mentioned before, estate planning is crucial, and estate planning means a lot of things. It doesn't just mean a will or a trust. It also has a lot to do with the disability planning that goes into it as well, because each of us have to think about that, especially if we're a caregiver for someone else, or we have children, or we have parents or grandparents that we're caring for, and we're in the sandwich generation. So wills and trusts are extremely important. As Diedre mentioned before, if children have a disability or are receiving public benefits, or any other individual, they may need special needs planning. Another, thing I want to mention too, that Diedre mentioned before, was, not updating. And it's not just updating your will, but not updating any of your documents can be really detrimental, because laws change, life changes, and the people that come in and out of our lives change. And so in this case, if you all remember Anna Nicole Smith, she was married to a billionaire, and there was a lot of litigation with regard to her inheritance from her husband. But then later, when she died, she actually there was more probate litigation with her estate, because she unintentionally, or intentionally, depending how you look at it, did not provide for one of her children. So as Diedre mentioned before, there's really basic requirements for someone to be able to do a will in Colorado. They have to be 18 years of age or older. They have to have testamentary capacity, that they understand what property they have and who it's giving them to, who they're giving it to, that no one's forcing them to do it. And then there's some legal requirements with signing, dating, etc. And then essentially what people often ask us too is, what happens if I have nothing in place? If I have no will, I have no trust, I have no powers of attorney. Well, if incapacity happens, like we said before, guardianship and conservatorship may need to be considered. If someone dies without a will, then there's a formula under state law as to who inherits. And we see a lot of people with high profile lives who didn't put any planning in place. And Prince was another person who passed away with no planning. So there's a lot of people out there. It's something that we don't like to think about. In our materials, which you can access, those are available to you. It has like the formula for what happens if someone dies without a will in Colorado, just so you can refer to that. And also there's some description of the probate process in Colorado with regard to what is the court process if I pass away, and whether I have a will or I don't have a will, what does that court process look like? As Diedre mentioned before, it can be very time consuming. It'll take at least a year. And the reason for that is when a person dies and has creditors have a right to get paid up to 1 year from a person's date of death. And depending on what was anticipated and what was prepared, whether they had a will or not, also play into how complex that probate process may be. And probate differs from state to state on the laws pertaining to wills, trusts, the laws pertaining to powers of attorney, and all of these issues, guardianship, conservatorship, all differ from state to state. So that's also just important to be aware of. So I think we are just about up on our time, but I wanted to address a couple of other questions that have recently come up about guardianship and conservatorship in our office. Some of the biggest questions that people have about guardianship and conservatorship is, well, who should serve? And I think that question is really important, not just for guardians and conservators, but especially when you're looking at any kind of disability planning documents like powers of attorney as well. Because if you are healthy, you're able to go do a power of attorney. And as Diedre said before, you should take action and seek to do so. But I think the biggest thing that you need to be aware of is the fact that just having your planning in place can really avoid a lot of conflict for your family. So I think at this point, I think that's about the main issues I wanted to cover, because I wanted to make sure that we leave plenty of time for questions. So Lindsay, I don't know if you have some questions that you want Diedre to address, or myself.
Great. We did have a great amount of questions that came in today. And so I think what I'll do, since we have two professionals here, we'll ask some of the questions, and then whoever is more comfortable answering, we can go back and forth, anything like that. So I did want to start off just by letting everybody know that, because this was a panel and our presenters had to cut it a little bit short, their presentations will be available on our website. We are recording this webinar and it will be published there. And then their PowerPoint slides will also be available in our resources tab as well. So I'll talk a little bit about that at the end of how you can find that, but we'll just jump right into questions. So to get it started, what is your opinion of a Colorado beneficiary deed if you have a will and elect not to have a trust?
I think Susie, yes, I don't know if Susie wants to take that. I'll just say that the big issue with that is incapacity, because you have taken care of where your property goes when you die, but you haven't done any planning around what happens with your property if you become incapacitated. So that's a one-way ticket to conservatorship. You could avoid it by using powers of attorney and other documents, but the beneficiary deed doesn't provide any incapacity protection. And I just read, I think it's the AARP, said 70% of Americans will be incapacitated at some point in their lives.
Yeah, I think the beneficiary deed, if you have a very simple estate and say you're up in age, you're 85, 90 years old, but you're in fairly good health and you think you're going to stay in your home until the end, so to speak, a beneficiary deed may be an option for you. But the only caution I would have is in the event that the person doesn't have a lot of assets and they may need Medicaid qualification to help pay for long-term care, if they have a recorded beneficiary deed on their house, that actually could impact their ability to be eligible for Medicaid. Because if your home is inside a trust, or if your home has already been pre-deeded through a beneficiary deed, and you go to apply for Medicaid long-term care, then that asset would be counted against you. Your home would be counted against you, whereas otherwise it would be considered an exempt resource for Medicaid eligibility. So I would say for some people, a beneficiary deed may work fine. For others, I would proceed with caution and make sure you get some good advice specific to your situation, because everyone's situation is different.
Great. So how do you find professionals to be a personal representative if you don't have a friend or a relative to do so?
In our practice, we have a couple of places that we recommend. The two main types of choices are banks and trust companies that will charge a percentage of the assets, typically 1% per year, to administer the estate. And then the other option is folks like Susie, and there are some small trust companies where you're hiring an individual who will probably charge an hourly rate and perhaps give you more personal care, but fewer of the benefits of an institutional, the things institutions can provide, website interfaces and things like that. What do you think, Susie?
There's quite a few private fiduciary groups now kind of cropping up around the state, and it differs from state to state, because I know in some states fiduciaries are more regulated than others as far as, and when I say fiduciaries, I mean non-bank, non-trust companies. And there are some that will serve as personal representative or trustee or even as financial agent. Again, what I tell everyone is go with someone who's well known in the community. Talk to different attorneys who are elder law attorneys, trust and estates attorneys, who know who the good professionals are and the professionals that are recognized by the court. And you also want to make sure those folks are insured and they're bonded. That's really important.
Great. So next is kind of a two-sided question. So is there special wording required to protect assets given to beneficiaries of a trust from their husbands and wives? So for example, if they were to leave their assets to a niece, are they automatically protected, or do they have to be split with their spouse? And then just really quick on the other side of that, somebody had that question kind of backwards. If they were to leave it to somebody, is there a way that they would split it with their spouse? So
I'm not sure I understand the question. I think, are they asking, can they leave money to someone other than a spouse under Colorado law? Is that the
I
question?
believe so, yeah.
Okay. So under Colorado law, a spouse has something called an elective share. And once you've been married, I think it's 10 years, the spouse is entitled to half of your um, half of the property and any separate property. So if you disinherited your spouse or left them less than half, they could go to court and get half. It's in the statutes. It's legally their right. They might not choose to if they understand your plan and they agree with it, but you have to recognize that your spouse is going to be legally entitled to half.
Awesome. Okay, sorry, I'm just going through here, making sure I cover all of our bases. Okay, so this person had a question. Am I correct to assume that the guardianship or conservatorship for a family member takes place in the courts of the state in which the subject of the action lives?
Yes. Generally speaking, yes. The jurisdiction of where the guardianship and conservatorship is brought is generally where the person lives or where they own property, real estate. And so, yeah, generally speaking, like if you brought mom here to Colorado, depending how long she's been here and what her ties to Colorado are, it's very likely Colorado would take jurisdiction, especially on an emergency basis, if an emergency arose. But it really depends on a case-by-case basis.
Okay, great. I'm glad you knew that one, Susie. I had to read it word for word because I wasn't 100% sure. So what is the price range for creating a will or a trust or powers of attorney? What does that kind of look like for somebody?
Well, in our office, we use flat fees. So we charge a fixed dollar amount for the plan that we're going to create. And plans really range in value and cost because I can't tell you right now whether you're an individual or a couple, whether you need trusts for your children, whether you're going to do a will-based plan or a trust-based plan. So I would just say you're looking at multiple thousands of dollars, and where it falls on that spectrum from maybe 1,500 to 6,000 really depends on your particular circumstances.
Yeah, and I would agree with that. I think everybody's situation is so unique and so different. It's really hard to give, just a flat. I mean, we charge flat fees as well, but it really depends. And it depends if you're planning for people who, may need some kind of special needs planning. There's so many moving parts. And so it's a tough range to estimate.
Awesome. So this one's more of a situational question, but if a person is single with no dependents and assets about 500,000, is a trust needed at that point?
I would say it depends on what their goals are. If they have someone they really want to have that money, and the 500,000 is in real estate, I would say trust makes sense. If they don't really care too much how much it costs or how much delay there is in getting the money to whoever inherits it, then they may be fine with a will or maybe even just a beneficiary designation. But what none of those things address is incapacity. So even if you're single with no spouse and kids, you want to address what's going to happen if I'm incapacitated, who's going to make my medical decisions, who's going to decide how to spend that $500,000 for my care. And if you don't plan that up front, you're looking at a guardianship or conservatorship controlled by the court.
I would agree with that. And I think the other piece that's important for people to realize is what you may set in place now, like say you're in your 40s and you say, okay, I'm going to put this in place, my estate planning in place, and just provide for a trust for my kids. Or maybe I decide I'm going to do a revocable trust and, you know, still do some trust planning for my children. Life changes over time. And what I personally like about the trust planning is it allows you to amend over time, update over time, and adjust it to fit your life as time goes on. But you're also putting in some fraud protection. And from where I sit, a lot of times as a public administrator, I'm doing a lot of triaging of coming in an emergency where people have been financially exploited or taken advantage of. And I really personally like, and when we do planning in our office, we often do recommend trust planning because there's more checks and balances in place and you have less potential for power of attorney abuse, for people downloading a form, putting it in front of mom who has dementia and going and wiping out her accounts, for example. So the trust plan does allow for more protection and especially a lot more amendment and adjustment over time as life goes on and puts those checks and balances in place.
Great. So our next one is involving vehicles in particular. So should vehicles be titled in the trust name due to liability?
What we do is we transfer vehicles in using an assignment of personal property that stays with the trust. We don't retitle them with the DMV, not so much for liability reasons. Your liability is the same either way, but for perception reasons. We don't want you to get into a fender bender and then you show your ownership card and it shows trust on it. And then the other person suddenly has a terrible backache and their neck hurts because they think trust means big money. So we don't recommend retitling your vehicles at the DMV, but we do avoid probate on them by using an assignment.
I would agree with that. And there's also now a beneficiary designation option with the DMV for leaving your vehicles to someone that you can do, whether you do that through the trust or you do it outside the trust. But either way, we generally do not recommend that. And we have had cases where, especially if we're dealing with special needs trusts, we absolutely do not title that vehicle in the trust for various reasons. And there can be some residual liability issues there. So yeah, we definitely don't recommend that. You should say that outside the trust.
Great. So this one's a little bit more situational as well. So if our house is included in our trust and we want to refinance it for updating, for access and safety, does the trust affect the financial transaction of refinancing?
Most lenders will only lend to you in your own name so that the loan conforms with all the other loans and they can package them up and sell them on the secondary market. So you'll have to take the loan in your own name. You'll have to take the house out of the trust, get the loan, but then you can put the house right back into the trust. And there's a federal law, John St. Germain, that says that a lender cannot call a loan because it was placed into a revocable living trust. So you just take it out, get your loan, and pop it back in.
And then, so if we had a trust made in a different state, is it valid in Colorado?
It is valid in Colorado. I would suggest you see a Colorado attorney because when I look at plans from other states, they're usually filled with references to that state's codes. And if someone in Colorado tried to interpret that plan, it would be impossible. They would need to hire an attorney from your original state to interpret your trust because they need someone familiar with all those codes. So if you're coming from another state, I would really encourage you to meet with a Colorado attorney and update your plan to reference Colorado law instead of Illinois or New York or Florida.
Right. I would completely agree with that, especially if it's a specialty trust. And by that, I mean, there's lots of different kinds of trusts out there, but special needs trusts in particular have got to conform to each state's own Medicaid, Social Security, Medicaid regulations, the Social Security regulations, and any local other type of agency regulations. So it's really important for special needs planning to make sure that that's reviewed state to state. And I would also say too, for asset protection trusts as well, because those trusts are only allowable in certain states, and you want to make sure you know what kind of trust you have and what state law controls, and make sure that, if you're now a color resident, everything comports.
All right, then moving to the next one. This one says, other than possible changes in the limit of how much can be inherited tax-free, are there recent changes in the law that we should know about for estate planning reasons?
I would say the Secure Act might be something that you want to talk to your financial advisor about, and that has to do with IRAs or retirement plans and leaving beneficiaries on your retirement plans. That may be something that you want to review with an estate planning attorney and your financial advisor, especially if you have large amounts of money in an IRA that you want to leave to particular people, because that is a law that came into play just right before COVID. And it could have some issues for some people with their estate planning, but again, everybody's situation is a little different.
Yeah, I agree with that wholeheartedly. The Secure Act changes how your beneficiaries can inherit IRAs and when the taxes are due. And depending on how your trust is structured, those taxes may be accelerated or not.
All right. I have another situational question. So, my parents have medical and financial powers of attorney documents with each spouse is listed to the other. So, it seems appropriate until both are needing someone else to maybe step in and take care of things. Is that something which would need to be set up after one becomes unable to make decisions, or can that be pre planned?
They should definitely update their medical durable powers of attorney and financial durable powers of attorney now while they both have capacity, and name successors. Because if they don't, and I've had this happen where they only name each other, but they're both incapacitated, or one passes and the other's incapacitated, then we're having to look at guardianship and conservatorship. So it would be much better if they have those documents reviewed now and updated to make sure that they've got successors named.
Great. That actually answered a couple others that I had on here, so I'm going to scroll past. Let's see. Okay, so this one I think is a question that was for Diedre. So you had mentioned that joint tenancy isn't necessarily the best path. So does an asset in joint tenancy pass out of probate? Is this a good thing? And what are some pros and cons?
Okay, yeah. Joint tenancy avoids probate on the first death. So if you and your spouse own your house in joint tenancy and your spouse dies, you will inherit it without probate. But when you die, it will go through probate. So joint tenancy does work between a married couple, but it doesn't work beyond that married couple.
I think the other thing I would like to mention that Diedre addressed in her presentation on pitfalls is adding people onto the deed of your home as a way of doing cheap estate planning. Because when you do that and you add other owners on your home, you're creating potential gifting issues tax-wise, but you're also potentially opening your home up to, for instance, if I add my child on to my deed and he gets in a car accident, there's a judgment against him. Now suddenly my home could have a judgment against him, because that's now an asset of my child as well. So you just want to watch out for those unintended consequences, those types of issues.
Yeah, and I would add divorce happens a lot.
Yeah, definitely.
You put your child on the deed and then the child gets divorced and now a quarter of your house goes to your ex-in-law.
Oh my goodness.
That is true.
So do you have any recommendations, or what do you recommend for securing these types of like paperwork and all of these different things that you would fill out with your business?
Securing them? You
Yeah.
may, well, our process is to create an estate plan with a family through several meetings and discussions, and then we have the documents securely stored, PDFs on our server. Then we give our clients the paper copies, and if they would like PDFs, we put them on a secure portal that they can download those from. And we encourage our clients not to share the copies around too much, because powers of attorney in particular can be used even after you have revoked them. It's illegal to do it, but it can be done because the bank doesn't know that you revoked that power of attorney. So it's very important not to send copies around to people, and rather to let them know where your binder is in your house and what our name and number is in case they can't find that binder. Does that answer? Was that about
Yes,
security?
exactly.
Okay.
Yeah. And Susie, how about for your company?
You know, very similar. We do a very similar thing in terms of we prepare a binder of the hard copies for our clients. We keep digital copies on file. We give USBs, little, you know, for people to store those so they're mobile. We also recommend to people when they're traveling, it's not a bad idea to email yourself your documents so you could access them from anywhere, or someone could. But the same thing, really keeping tight control of those documents, especially the originals, because, you know, people, as Diedre mentioned before, we always recommend, you know, people take a look at these things at least at a minimum every 5 years, or when there's a big life event. And it's really awkward when you have to change your power of attorney and you've got to go chase it down and ask someone to send it back to you. But there's also that risk too, that they could be out running around using it and no one knows. So keeping tight control, I think, is really important as well. And we usually recommend like a home, like a safe, waterproof, fireproof safe in your home to store those originals, or someplace you can grab them quick if there's a fire, if there's a flood, all the crazy things that we saw in 2020. So having those readily accessible and not locked away in a safe deposit box is also one thing we always recommend to people, because that can be really difficult to get if you are not you're not on as an owner on that box, or you don't have the key, or you don't know where it is.
Awesome. Well, thank you so much to both of you, and thank you for your time and expertise. There were some questions that we weren't able to quite get to, but I just want everybody to know one more reminder. This webinar today was recorded, and so it will be posted on our website by no later than tomorrow, so that you have access not only to their presentations, but also this quick Q&A that we did at the end. Their PowerPoint slides will also be available, and then they input their contact information in both resources. So feel free to reach out to either Susie or Diedre or anybody in their offices. We are right about at 1 o'clock. I know I'm sure we could go all the way another hour, but I wanted to just say thank you so much to both of you, and that'll conclude for today.
Thank you.
Thank you, Lindsay. Thank you, Susie.
Thanks, Diedre.